Okay, guys, what we're going to be doing today is we're just continuing the civil or the tort notes that we've started in the past few days here. What we're going to be doing today is we're just picking up from where we left off, in that we're going to continue our intentional torts, but this is going to be not injury to person, this is injury to property. Now, similar to what we did the other day, I want to go ahead and give you guys the three types of property that are protected by civil law as well. We're going to get into each of these a bit further today, but I do just want to give them to you up front so that you know what we're going to be covering. Now, with that said, I want to give you just some real basic information as to these three types of property that are protected by civil law. And what you're going to see is there's going to be some crossover as well, where you're going to see that these are protected by civil law, but there can also be criminal law issues as well. So the first one we're going to talk about is going to be what's protected by civil law is real property. Now, I give you some examples here where, like, a house is real property. The land that you own that house is built on is real property, because really the defining thing about real property is it can't be moved. It's attached. Now, I bring this up because there is going to be the second type of property that's protected called personal property. Now, I give you these examples, but first I do need to explain personal property and real property are different, because real property you cannot move. Personal property you can move. It's easily transportable. So I give you these examples of, like, a car is personal property. Jewelry is personal property. A laptop is personal property because you can easily pick it up and move it. Real property is not that. Real property is attached. It's affixed. Now, the third one is usually kind of the most difficult because it's the least tangible. The third kind of property that is protected is called intellectual property. Now, just to kind of give you an idea about what intellectual property is, this is a creation of the mind. It's something that you think about. It's something that you invent. It's like a song that you make. It's not necessarily tangible like a car or jewelry or a laptop. It's not like a house. It's not like your land. It's something that you created, and therefore it's yours. You have a right to ownership of it. Now, I'm going to get into this more a little bit later on and how to protect intellectual property. But like I say, we're going to go through the first one, then we're going to talk about the second, then the third. So what we're going to start with today is going to be real property. Now, we're going to talk about first what the injury to property is going to be in regards to, like, a home or your land. What we're going to talk about first is going to be trespassing. Now, like I said to start, there's going to be some crossover here between the civil side of this and the criminal side of this. Now, first off, just to kind of get this out of the way, yes, trespassing is a criminal issue. You can be arrested for trespassing, and there can be any sorts of different punishments if the government does bring charges against you. It can be a fine. It's even a possibility it could be jail time. But there is going to be the civil side of this too, where if someone trespasses on your land, you can sue that person for entering your property without permission. Now, it's going to kind of depend on what the property is, where it takes place, what the actions of that person that is trespassing is going to do. But yes, it is very possible to sue someone for trespassing. Even if there is no damage that's done to the property, just being on someone else's land without their permission is in fact going to be a civil issue as well. Now, we've kind of talked about also how in Colorado especially, there's make my day laws where trespassing on someone's land, even if it is innocently, they can defend their property with deadly force if necessary. So trespassing can be a very serious issue, but it can also be something that a person can in fact pursue a lawsuit and sue someone for trespassing. Now, there's going to be another one that we can talk about in regards to real property. This is called a nuisance suit. Now, in regards to being a nuisance suit, I do just kind of want to give you the basics of it, and then we'll talk about application. So first off, what a nuisance lawsuit is the unreasonable interference with your ability to use and enjoy your property. Now, I kind of use an example and sort of build from here, where if you are sitting in your backyard and you are just, in a hammock, if you're reading a book, and a neighbor is playing music too loudly, that can be considered a nuisance. That's unreasonable interference with your ability to use and enjoy your property. Now, if you are going to call the police on that, yes, they can come out and they could issue that person a violation. They could give them a ticket for a noise violation. It's very possible. What's most likely to happen is the police will just kind of inform that person and say, your music's too loud. Will you please cease and desist? Now, hopefully that would solve the problem, because in order to file a nuisance lawsuit, you do have to prove that this is a repeated activity. It can't just be a one-time event. So if you're in your backyard in your hammock reading a book and your neighbor's playing their music too loudly, if it's that one time, then you really don't have a case for a nuisance lawsuit. Now, if it's a repeated offense, then yes, it's very possible. You could in fact sue your neighbor for playing their music too loudly. Now, I give this picture on the right here of this party that's taking place because this can very easily be considered a nuisance. This is going to be an example of where a neighbor could very easily call the police and the police could come to break up the party. Now, if it's a one-time issue, then you cannot sue your neighbor for this. If it happens over and over again, then yes, all of a sudden you do have recourse to sue your neighbor as a nuisance. Now, as we go forward here, we're going to switch and we're going to talk about injury to property, and this is now personal property. Now again, not real property, this is personal property, things that can be transported. Now for personal property, there is going to be civil protection if property is taken or interfered with. Now again, we got to go back to the crossover. Taking someone's personal property can be larceny, it can be burglary, it can be theft, it can fall under multiple criminal charges. But you can also sue someone for taking your personal property. You can sue them with what's called conversion. Now, I do kind of want to explain this, and then I'll give you an example here. If someone takes your property, and then you can no longer use that property to, for example, like do a job, if that costs you money by not having your property, then yes, you can sue that person who took your property for damages, because it negatively impacted you financially. So I do just want to give this quick example, as a friend of mine is a general contractor. He was on a job site and he did not have a tool that he needed to do a job. So he called up one of his friends, another general contractor, and asked him to use this very specific tool. My friend evidently just took longer than what he had anticipated. If I remember correctly, I think he took 2 or 3 days to actually use this tool to complete the job. The other contractor needed that tool back to complete his project. The fact that my friend had his tool and he couldn't do his job without it means that he was financially burdened because it took him longer to complete the job than what he had previously bid. In order to make up the losses, he actually sued my friend in court and won. So what took place was he said, I did not have my property, so it cost me financially. I need to be made whole again. Now, it didn't end up necessarily being that big of a deal, but yes, my friend had to pay him under conversion. Now, there is one last thing about this, as if someone does take your private property, you can, personal property, you can use reasonable force to take that property back. Now, you kind of have to keep in mind, as we talked about this during our criminal unit, where what's reasonable force is completely up to the eyes of a jury or a judge. Now, we kind of talked about reasonable force in the past where, yes, reasonable force is what an average person would say is acceptable to get your property back. But again, it's very much a gray area as to what reasonable force is. Now, for the last one, intellectual property. Like I say, intellectual property is kind of the hardest because it's not necessarily a tangible item. It's not like someone stole your laptop. It's not like someone stole your jewelry. Intellectual property is you have to prove that someone stole your idea. But in order to do that, you have to really establish the fact that it was your idea first, which means we have some systems in place to really prove whose idea it was first and how to protect it. If it's your thought, it's your property. So, with that said, I always kind of just use the example of music in this, because if you're an artist and you create your own music, what you're doing is it's your thought. Now you're producing it, but really anyone could just take that away from you. Anyone could reproduce your song. So you have to be able to protect that. We really have kind of two ways where, legally speaking, you can protect intellectual property. And it comes with patents and copyrights. Now, patents and copyrights basically serve the same purpose. They are going to be establishing who is the rightful owner of that intellectual property. They're just very different in how they go about it. So first, if you do in fact file for a patent, it requires a fairly extensive legal process, and it can take a considerable amount of time. It can take years to officially get a patent. But those patents, once they are created, once they are given to you, they only last for 20 years. Copyrights are a little bit different. Copyrights do not require a legal process, and they exist really as soon as you just create it. All you really need to do to create a copyright is just file paperwork and just register that copyright with the U.S. Copyright Office. Now, once you create it, it's in place. Now, a copyright can be used really for any kind of idea. It can be music. It can be, a symbol that you create. There was one that came up recently where there are multiple athletes that are going to use different, I guess you could say, kind of symbols about them. Tom Brady happens to be one. He put a copyright on basically a symbol that's called TB12. It's kind of his own little brand. He has a copyright on that, so anyone that might put a TB12 on like a t-shirt owes him royalties because he has the copyright. Now, copyrights also are going to last considerably longer. They last the lifetime of the holder of that copyright plus 70 years. So for the rest of Tom Brady's life and 70 years after, he has the rights to anyone who prints TB12 on a t-shirt. They owe him because it was his idea. These patents and copyrights, they're going to recognize your ownership of that intellectual property. Now, if something like that were to come up, say if someone did put a TB12 on a t-shirt, Tom Brady could in fact take them to court and sue them for royalties. Because he owns the copyright, he can sue based on infringement. Now, I give you guys these examples to the right here. There was something that was created in the late 1990s or the early 2000s. It was a computer program called Napster. It's kind of a little bit old now because Napster got shut down back in, I believe it was 2003 or 2004, because this was a computer program that basically took all millions of songs created by artists and put them into really one big kind of, I guess you could say like a holding website, and anyone else could download them for free. Now, that is a clear violation of their intellectual property. You are taking their songs and downloading them without paying them. So, of course, the artists that came up with these songs are going to try to sue Napster. Now, in doing so, it got very complex in regards to the legal aspects of it because the Napster website basically said, it's not us that's downloading them. It's other individuals. We're not the problem. It's the individuals who are downloading them are the problem. So they went after the people who were downloading them. Now, there were millions of people downloading these songs, but there was one person in particular that becomes kind of the face of this. You can see him on the bottom here. His name is Joel Tenenbaum. He downloaded 30 songs from Napster. All of those songs were going to be sued over based on infringement. This person, Joel Tenenbaum, was ordered by the court to pay $675,000 for violating for violating the intellectual property. Now, they weren't wrong. He stole their songs and didn't pay for them. So technically, yes, they should sue for this. Now, this is going to wrap up this particular lecture. We're going to continue later on